Hi, good morning. Today is May 22nd, 2026, and it is 7 a.m. US Central Time. My name is Rinaldo J. Aguiar Marcano, and I'm recording this from my office located at the 2302 Britton Ridge Drive, Katy, Texas 77494. And this property is located 300 feet away from the residence of Mr. Robert Mueller, who is a former director of the FBI, and that is relevant to this conversation. And also 300 feet away from the residence of Mr. Robert S. Clark, who is a prominent family law attorney here in Katy, Texas. And that is also very relevant to this conversation. And it's also located 300 because they are live together, right? Next to each other, to the house of Daniel King, who is a reverend at a church that has no religion. This is related. You'll see. Anyhow, this is declaration D136, D136. This is the third part of that, the third segment of that declaration. It's going to be a long session because I have a lot of things that I haven't said that I think I need to say. And I haven't because in the last 10 days I haven't recorded one of these, given that this is a live case and this network is operated by a network of judiciary officers. And anything I say will be used against me. So I have to be very careful. So I thought, it was the prudent thing to do was to not to record one of these while this thing is live, right? And it's still live, but I think 10 days have passed. I need to say something. Anyhow, so it's going to be mostly on the legal side of things. There are another set of observations, but I'll try to move that to the second part of this segment. Also, I want to tell you that I'm gonna give you as much because it's a lot of things. I'm gonna try to do this as fast as I can, and I'm gonna try to do it in a way that it's objective, at least from my point of view. They of course will see it differently, or will see things differently. But all I can offer you is what I can see from my point of view, and I'll try to do that in the most objective way also. But before we get into that, I want to tell you something that really didn't happen recently. This is something that happened weeks ago. But I need to say it because it's a way to take away the candy from them. Right? You'll see what I mean. So a few weeks. Let me give you a bit of a backstory. Very short. The short version is a few weeks ago. I was communicating with this informant that is working on that team. Like he passes me information, but he tells me things to help me. He's helping. But he's really working for the opposition, right? For the adversary, and he told me. So the conversation started, right? Because there was a question that I had in my mind that I could not figure out, right? And again, I'm telling you this in the most objective way I can. Like, I'm not taking this personally, and I'm not trying to be dramatic here. But I'll tell you what was my thinking. Okay, my thinking was, and this is something that I hadn't figured out right until I had this conversation with him. My thinking was, assume for a second that they managed to harm me physically, right? I'm no longer here. Right? I think that would be a very dangerous situation for them, financially, economically, because of the patents, the patent applications, and the invention. And here, I want to be very careful, right? Because when I say these things, I know they may sound like I'm exaggerating the importance of those applications. But I have to tell you that I'm a technical person, and I can see how those inventions will become very important. in the next few years. Um, and I can see how the existence of those inventions and the license grant I gave to the federal government, free of, you know, royalties, licensing fees, anything, perpetual, is going to cause them a great financial harm long term. I can see that. Right? And like, I guess we will only know when this happens, right? But from my point of view, it looks that way, right? So the question I had in my mind was, well, assume that they harm me. It's going to be worse for them because then the sole entity that would have control of these patents will be the federal government, and they will never get a license from them, right? Obviously. Um, so it is in their best interest that I'm not harmed, right? In a way, right? Because at least they have some room, right, to move, some latitude, right? So that didn't, compute in my head why they keep trying to harm me when that is going to inevitably cause a great financial damage for years, right, to them. So so I asked this question to inform, right? So the person that passes me information that is really working for them, right, but is helping. Uh, and the answer was chilling, really. Um, So yeah, I'm gonna repeat exactly what he said, right? And I'm gonna basically just give you a summarized version. But basically, what he told me was that, well, a few months ago, when we broke into your home, we stole. Uh, I think they stole the box. Like, I had a safe box that had. It didn't have anything valuable there because when I left last in 2024, I left the Valley Side property, right? Fearing for my life. And at that time, I moved to this property, which is not my office. But during that time, in 2024, I lived in this property. Right? And when I did that, I took all my documents and everything from that safe box. It's not really a safe. It's like a fireproof box. It's against fire. It's not. It doesn't have a strong lock or anything. It's just to protect documents from fire, right, or water damage. Um, But anyhow, I took, the things that were important to me, like the titles of the vehicles and things like that, from that box, and I brought them here. Uh, uh, I can't recall exactly if I left the box there or if I brought it here, but it doesn't matter. Like, what he told me was that in one of the occasions that they broke in, they stole the box or they stole the contents. I have to look for the box. I haven't done that because with all these things, I haven't had the time. So I don't know if the box is in Balisai. But anyhow, the point is that in that box, there was my last will and testament. And that's what they were after. So I don't know if they stole the entire box or if they only stole the last will and testament, but they did steal that. Now, I have to tell you, this last will and testament was a document that I wrote, I prepared in 2020. I think it was at the end of 2023 or early 2024. And this was after an incident with one of the younger of the Moleros, one of the younger boys of the Molero Villamizar family, when he almost ran me off the road with his Escalade. So he has an Escalade, and this is documented in my books. I have the plate and even the registration sticker of the vehicle, right? It was an Escalade. I think it's a Tahoe. It's a large SUV, black SUV. And the license plate is SCTLND, right? And I remember because he almost ran me off the road, right? Almost killed me in that occasion. Um, he was seconds away from causing a very serious accident. What I'm trying to say. I was not harmed. I didn't crash, but it was a close call. I would call it that way. When I saw that happening in 2023, I'm telling you this. I mean, this happened more than 3 years ago. Right? When I saw this, my first instinct was, these people might kill me. So I, might, you know, prepare testament, right? Because my son was already, born, um, and I worry, right, about mostly the intellectual property. It's not, I'm not a high net worth individual, but I was worrying about the intellectual property of the things that I was working on back then. That they were, I mean, the Chinese were trying to steal at that point, right? Using Travis Kalanick and Bob Briscoe and those people, right? So I prepared the last will and testament, right? And because the child was already born, what I wrote, I did this on a horror. Like, of course, for obvious reasons, I could not go to an attorney to do this. I did this on my own without having any knowledge on how to do this, right? So I basically wrote a document and leaving everything to be administered by who is now my former partner. Um, so basically, what the informant told me was, well, it's simple. We stole your testament, and you are leaving everything to her. So if you are no longer around, she is going to be the sole administrator of everything, and we're going to get it from her. So that's the plan, right? But I have to tell you, I changed my last will and testament. I prepared a new one, and it's in a. Of course, I'm going to disclose the contents of the will, but I have a brand new that supersedes any other wills that could appear, even if they are never found or haven't been found yet. This supersedes everything. And in this one, my former partner, Gloria Espina / Suleiman Molero Villamizar, is not named at all. Like, she's not, I'm not leaving anything to her. And I'm saying this is not retaliation. I think it's to take away the candy from them, because as long as they have that will and they think that it's valid, they will have a motivation to harm. So, bad news, the motivation is gone. That will is no longer valid. So, I think it's important to, to get that out of the way. So with that, let's move on to, well, and I don't know, like, this could be interesting as well, right? I mean, it may have some investigative value. I mean, if that will is ever found in the possession of, any of these judicial, I mean, I imagine they must have, let's say, because, this network, what they do is steal intellectual property. That's the end goal of the enterprise, right? And I described this in previous demos and declarations. Why, right? So I imagine they must have this document stored somewhere, like they're not going to destroy it, right? Because they think they're going to get the patents that way. So if this document is ever found in the possession of any of them, I think this would be nuclear, right? All right. So with that, let's transition to the real content of the main content of this declaration. And let me start by sharing my screen with you, because I have my talking points, my notes, the things that I want to say. Um, okay. So let me open this. Yeah, so we talked about the changes, right? So the changes is the changes to my last will and testament, and this one, the new one, supersedes everything that I've ever wrote or said in any kind of communication. Like, this is the will, the new one. Um, and it's dated in the month of May 2026. Anything before that, please, don't. I'm talking to, potentially, right? If this ends up happening, so there's a record that anything that I wrote before May 2021 in this, May 2026. In this regard, anything that I wrote before is void. Like, this supersedes everything. Okay. So now let me transition more to these things. Okay, so now I'm going to talk about more about the legal topics and the updates, right? So before I start like diving into this, right, because my goal here is to give you a timeline of what happened in this case. I mean, I'm doing this so if anybody finds this declaration, I mean, from the real authorities, they have a roadmap to see, what are the important things that happen, right? What were the important milestones in the conflict? So they know quickly where to look, right? That's what I intend to do here. But before I get there, or I get to that, let me tell you why I'm doing this. It's because there's been a tremendous escalation on the legal front of things from their side in the last 10 days. And all this at the end resulted in a capias order. For people that are not, I'm not an author, right? I have to learn these things to fence them off. But for people that are like me, that are not trained in the legal profession, you'll need to know that a capias order is basically an order for an arrest of a person. It's an order to put somebody under arrest. So they issued a capias order. I haven't committed any crimes. The reasoning behind, or what they think is the legal justification for the order, is that they supposedly issued an order for me to appear in court, and I didn't show up, and that is contempt of court. So that gives them the right to issue a capias order, and it is issued and signed, right? And this is according to the docket, to the official docket. So they signed the order. So there is currently, today, in this moment, there is an order for my arrest that is already signed by a judge. So this is a tremendous escalation, right? From everything that, before they kidnapped the child, they harassed me with the courts and all, but now it's arrest, right? So it's an escalation. Um, Now, I also have to tell you that my position is that first of all, they never served me with the order to go to any. There wasn't a hearing. They didn't even notify me that there was a hearing. They didn't serve me with the order. For all those reasons, this is void. Like the order to appear, like the supposed cause of that capias order, is on itself void because they never served me with the order or the hearing, or like I wasn't even there. And they do this on purpose. Like they send the notices to the wrong address, so you cannot go to the hearing, and therefore they can do anything they want, right? But beyond that, the more important reason why all these sequence, including the capias order on itself, all those orders are void, is because this particular court in this particular case is under a mandatory and automatic stay, meaning they cannot do anything. They cannot schedule hearings. They cannot have hearings. They cannot enter orders. They cannot enter motions. They can't do anything. The court is in recess. The reason is because there is a third verified motion to recuse the judge. A motion to recuse is a petition made by one of the parties asking for the judge to recuse himself. According to Texas law, the judge has the two options. He can agree to recuse himself, or he can say no, but then he cannot just continue. He has to forward that motion to a superior judge. Okay. And superior judge could be an administrative judge. And if that administrative judge doesn't want to rule on that motion, that administrative judge can refer that motion to the Supreme Court of Texas. That's the way it works. So this is exactly what happened in January 2026. I filed the motion. The judge denied to recuse himself and forward the motion to the Honorable Susan Brown. The Honorable Susan Brown, because in that motion, I also asked for the Honorable Susan Brown to recuse herself. She didn't. She declined. And she forwarded the motion to the Supreme Court of Texas. Now, the Supreme Court of Texas hasn't ruled on this motion since it was referred to them. It was referred to them on January 27, 2026. So for all this time, we've been waiting for the Supreme Court of Texas to rule on that motion. And during that time, it's not something that I'm saying, it's something that is written in the rules of civil procedure of Texas. The court is under a mandatory non-discretionary stay, meaning they can't do anything. But they have to keep scheduling hearings, not inviting me to the hearings, not notifying me of the hearings. They have the hearings, they enter orders, and then they don't serve me the orders either. And then when I don't comply, because I never even understood that there was an order, that there was a hearing, then they find me in contempt. And then they're gonna put me in jail with another order that it's also void for the same reason. The court is under stay; they cannot be entering orders. Anyhow, that's the whole dispute, right? I have to tell you, before I dive into the sequence of how we got to this point, I think this is a tactical mistake that they made. The reason I say this is because, I don't know, if somebody analyzes what happened in this case at some point, if somebody does a post-mortem, you will see that the main vector of harassment really is the fact that the judge never takes action, right? When I file a motion, I have filed more than 80 motions in this case. He hasn't ruled in one of them, not even one, right? The contrast of this is that every time the opposing counsel files any kind of motion, not only it gets promptly processed, but it gets granted immediately, right? Without hesitation. Uh, even if the court is under mandatory stay, right? But what I want to tell you is that the main vector of attack is really inaction, right? And not taking actions that would benefit the defendant, while at the same time taking actions that will harm him, right? So this, of course, tips the balance in a way that it's unfighterable. But you see, this is what I think. This was a tactical mistake, because if that's the main weapon of attack, they should not have issued a capias order. Why? Well, because when there is a capias order that is live, meaning something that is threatening the liberty of a person, that person has a recourse. Like they have a possibility of filing something that is called a petition for habeas corpus at a higher court. This is a special type of instrument that allows a person to petition to a higher court to intervene swiftly to protect their liberty. Right? If somebody has the threat of being put in jail, they can file this thing, and the higher court is obligated to address that immediately. I mean, that has higher priority than any other filing in that court, and this is typified in the law, in the rules of procedure of these courts that dictate how these courts work. And this is because they need to the lawmakers wanted to protect, right, the basic liberties that are guaranteed in the Constitution. I mean, this is a constitutional issue at this point. So there is a mistake for two reasons. One, because they created a situation that mandates higher courts to act with non-discretionary power to delay making a decision, which wasn't the case before. In all the other orders, like, if they seize the child, if they, those courts, the higher courts, have some discretion on whether, for example, like to give you a clear-cut example, the motion to recuse. That motion to recuse is important because it touches on an issue that has a child kidnapped for more than a year, and still the Supreme Court of Texas has discretion on whether to rule on that today or next month or in 6 months. Right? They have some discretion, absolute discretion, it seems, right? But if it's a petition for a writ of habeas corpus, they don't have that discretion. They have to rule on it immediately because there is the liberty of a person at stake. This is not a dispute about a child. No, I'm not saying that children are not important. I would say that, but children are not protected in the Constitution in the same way that freedom of movement, for example, is. Um, so this creates a situation in which the higher courts are obligated to act immediately, which disables the main vector of attack that they have, which is the inaction of the court in things that would help the defendant. Right? So I think it's a terrible mistake, but it was a terrible mistake. But that's one of the reasons why it's a mistake, because it creates a situation when there's urgency to respond on the higher court or courts. And I'm going to give you more details on why I say plural here. But anyhow, so that's the situation, right? And that's exactly what happened. Right? When they did this, I immediately filed for a petition of habeas corpus with the First Court of Appeals. They ignored me. They haven't even ruled on that. But that, again, is a mistake because that opens the door for me to go to the Supreme Court of Texas and file a similar petition a petition for writ of habeas corpus. And this is nuclear because that court has already been delayed for, 4 months. So since January 27, they received that, right? February, March, April, May, almost 4 months, right? They haven't ruled on that motion to recuse, which is not the order that directly has, or not, it's not the issue that directly has the child kidnapped, but it's allowing the child to be kept in that state. And now they've received this petition of habeas corpus, for habeas corpus, and from the same defendant, right? That has been telling them this for 6 months at this point, because before that motion to recuse, I also filed other things with the Supreme Court of Texas. Right? So it seems to me like it's a horrible mistake. I mean, to issue that habeas orders in the first place. But anyhow, also important to tell you, when they issued the order, here in Texas, I'm going to give more details because this varies in different states and it may be different in other places. I'm going to tell you how, from what I see, right? I'm not an attorney, but from what I can see, it seems like it's a multi-step process. Right? So the first step is the attorney, G. Troy Pickett, files a motion for contempt of court, and there's a hearing in which, in this case, they didn't invite. Right? Then the judge in the hearing verbally says, I'm going to sign that order, right? He grants the motion. But this is verbal. At this point, there is no order yet. Then the next step in the process is like a pipeline. The next step is G. Troy Pickett, I imagine, drafted the actual order. Now, and this is interesting. If you look at the timeline in the docket, G. Troy Pickett filed the actual proposed order 45 minutes. I think the hearing was at 9. He filed it at 10 a.m. So within 1 hour, he filed the actual proposed order. And this is important because if you read that order, it's a very technical document. And it explains what happened in the hearing. So I don't know. I'm a logical person. I have to ask myself, how did Troy Pickett, in 1 hour, manage to go to the hearing, understand everything that happened, memorialized it into this digital document, format it, and print it and file it, or file it electronically? All of that in 1 hour. It seems to me like he knew what was going to happen in the hearing just by looking at the times of these things. I mean, it's highly suggestive of that. Unless he was doing the document live in the hearing, and this should be visible in the cameras. If he had a laptop with him and he was typing what was happening. But anyhow, put that aside. G. Troy Pickett files the proposed order, and this is the document that would become the order, but it's not signed. Then the next step, and all this should be in the docket, right? The next step, and he has to serve that to me. Then the next step is the judge signs the order, and there should be a docket entry that says the judge signed. But at this point, the order is not yet visible. This is just an entry. Let me show you. I think it's better if I show you um, here live in the docket, right? Right. So if you see here, yes. So on May 14th at 9 a.m. was the hearing, and it says enforcement contempt hearing, 9 a.m. Judicial officer, Telfair Oscar III. Okay. All this is in the same date, right? This is all the things that were filed, but and I think they do this to add noise, really, because it's such a coincidence that every time they're going to do one of these dangerous orders, there's a bunch of letters that come into the docket, right? I think it's just to add confusion, but ignore the letters. Go to index 213 and 214. So 213 and 214. You see, it says proposed order. So the type of document is proposed order. This is not the actual order signed. It's the order not being signed. This is what Troy Pickett filed at 10 a.m. You know, maybe the hearing, maybe he was still in the courtroom when he filed this. I don't know. I don't know because I wasn't invited to the hearing. I wasn't notified that there was a hearing. So you see, then there's the judge docket entry, right? That explains that I was not in the hearing and that they called my name. Of course, I wasn't in the hearing because they didn't notify. And then he says copies to be issued upon filing, and then he initials it with his initials, Oscar Telfair, OT, right? Then there is another docket entry on the next day. This is Friday of last week, May 15th. And it says the court signs the copies, right? And its initial again, Oscar Telfair. So this is telling everybody we signed it, right? But the next step after this is that there should be an entry for the order itself signed. And it should be stamped by the clerk with the electronic stamp on when it was filed. This is because, to protect the person that is being harmed with the order, because, or that's been affected, let's say it that way, by the order, because, there is no guarantee that what the judge signed is actually what was proposed, right? Like, for example, I'm not saying that he did this, right? But imagine that Detroit Pickett tricks the judge and files one version of the order, but when he's going to take it physically to the judge, or the clerk tricks the judge, right? When they're going to take it physically to the judge to sign it, they switch it, and they give it a different order that has a higher bond, for example. Instead of 2,500, it says 25,000, for example, right? So to protect the person being affected by the order, they need to post in the docket the actual order. And more than that, in the case of pro se litigants like me, people that don't have an attorney, they are obligated to serve a copy of the order by mail. So the person is informed, the order signed, the signed order by mail, right? And as you can see in this docket, after the index 214, there is nothing that says order. Like the actual order is not in the document. Right? I cannot download it. And it's also not served. There is no entry that says we sent it by mail. Like you can see, let me show you another order to see what that would look like. So you can see, right? Okay, so you see, for example, this entry on index 91. This is a different order that happened before, right? But it says, sent to all pro se parties, RTS attempted, not known, unable to forward. So this is what it should look like. I mean, it should say that sent to pro se parties, right? Meaning that they sent a copy of the order, that is the new order that was signed, that was just signed, to everybody that is acting pro se. So they have, full knowledge of what the order says, signed, the signed version of the order. Now, this case is interesting because this is the order of that has a child kidnapped. And it says right there that this order wasn't, I mean, it says unable to forward. This shows that I never got the order. This is what this shows. It's written on the docket. They sent it, but I didn't receive it because for other reasons. They have my mail blocked, but I don't want to get into that, right? But this shows that I didn't get the order, right? And this is important for them because this is a way for them of saying that I have no way to prove which is the real version of the order. That's why they're doing this, right? This is to protect themselves because any order that I show, they will say, but how can you have the order if you never received it? You see? It's a way to discredit any version of the order that I can produce. But anyhow, in the case of the capias, which is the matter at hand here today, there should be two more entries. There should be one entry for the order signed, and there should be an entry for them sending me the order by mail, as required by the rule. I think it's Rule 22. I think in the rules of procedure. And those entries don't exist, as you can see here. Right? There's no order, and there is no there is no proof that they served me the order. And I think this is probably to protect themselves, right? Because now taking the step to give me the order, that it's, giving me proof that they are going to put me in jail, right? And they know I'm a federal whistleblower, and they know that I've reported many of these judiciary officers to the IRS. And putting the whistleblower in jail using the court is, it's a crime. So they can't put the order. I imagine, right? That's the reason. They can't put the signed order in here because that would be giving me evidence of another crime that is very serious. So they left it in this state, right? But now this creates a tremendous, terrible situation for me personally, right? And I don't want to, again, I'm trying to do this in the most objective form possible, right? And believe me, it's hard. It's hard to do. It's hard to not take it personally. But in my specific case, and this is something that is specific to me, right? This doesn't apply to anybody else. This is my personal situation. I don't have any family here in Texas. So when they produce this docket entry, right, that says the court signs the capias order, in all practical senses, I am under house arrest. Why? Well, because for example, let me give you a concrete, real example that is happening to me right now. I ran out of food days ago, and I can't buy food because if I go to the store, I mean, until today, right? Probably today I will be able to, but before today, if I had gone to the store, And remember this, so today is 22nd. This thing was signed on the 15th, right? So from the 15th to the 22nd, I have not been able to leave the house even to buy food when I have already run out of food. The reason is because if I drive my car to the store and they detain me with the police, they're going to impound the car. And this has, there's more. It's not just about the car, right? In that car, if you watch the previous declarations, you will see that in that car I have equipment, technologies, things that I use to fence them off, and I don't want them to get their hands on that technology, right? Because that's what they do. They steal technology. So if I go buy food, I risk that they will impound the car and they will steal the technology, right? So by all practical, in all practical senses, I cannot drive, right? Um, and if I can drive, I can go buy food. And you could ask yourself, well, can you take an Uber? Well, Uber is a company that has been stealing my intellectual property for years. And Travis Kalanick, I named him. Travis Kalanick is the founder of Uber, right? I filed a lawsuit against Travis Kalanick in the federal court. For obvious reasons, I will never in my life take an Uber. I sent legal notices to the current CEO and the chief legal counsel of uh, Uber, putting them on notice of infringement of my intellectual property and asking them for a litigation hold. Right. So I mean, it's a highly contentious situation. I'm not going to take an Uber to go buy food. Um, but beyond all that, what I'm trying to tell you is that in all practical senses, this docket entry, although even there is no document signed and it wasn't served to me, the existence of this entry in there, by all practical means, puts me under house arrest. I'm in a situation in which I cannot go to the store to buy food. Right? So let me tell you what I had to do. I had to ask my brother to come from Canada, to take an international flight and come from Canada to take me to buy food. And he's here today in Katy to do this, right? So this give you an idea of the impact of that simple docket entry in there. Now, I'm not an attorney, right? But I've been, doing some, I've been looking up online, and it seems like there's precedence for this kind of thing. Like this is not the first time this happens, right? Like that a judiciary officer abuses their power and without signing an actual order, limits the freedom and the liberty of a person. And that is a crime. And it's worse if it's a whistleblower. And it's worse if that whistleblower reported the judiciary officer that is doing this to a federal agency, right? Like the DOJ, as I did. So I don't know. It seems to me like it's, as you can see, the situation is escalating, right? Now I have to tell you, I've known for months, right? That I mean, because I see the things that they do, and I knew that it was going to get to something like this, right? I didn't know the extent or how exactly it would happen, but I understood months ago that the only logical conclusion is this, right? But I don't know, like this creates a situation in which somebody is going to end up in jail. It could be me or it could be them, right? But somebody is going to end up in jail because now there's a capias order and this is something that cannot be deleted. Because it's in the docket, it's in this video. Like somebody is going to end up arrested. It's either me or them, right? So I don't know. With that, let me transition to a kind of a timeline of, well, before that, because we're talking about this, let me tell you how I responded, right? So I filed the petition for habeas corpus in the First Court of Appeals. Let me demo to you here how you can find these things if you want to look them up yourself. You can Google 1CA, as in First Court of Appeal, Texas. No, sorry. It's better if you type First Court of Appeals, Texas. Here you click on case search, and you would have to search for this case. This is a current case, right? There are other cases, but this is a current case. 01 26 00 516 dash CV. And you can see here there is a petition for habeas corpus. And if you click on this, you can download the actual document. This is interesting. They removed the attachments from the document. This document had attachments, and they removed them. See, it had 4 attachments, right? A, B, C, and D. Let me see, because I think this was. Oh no, they didn't remove it. This is not the one that has the full attachments. It's the other one. Okay. Okay, but this explains the issue with the captains, right? But they didn't, in the first court of appeals, they didn't, take any actions with this. So of course, what I did is that I escalated this to the Supreme Court of Texas, and that has more interesting attachments, right? That's what I want to show you. So if you do a Google search for Supreme Court of Texas, here, you do case search, right? And the case you're looking for here is 26 0511. Sorry. I want to repeat that because it's an important number, at least for me. Okay. It's yes, 26 0511. 0511 is the last 4 digits. And you can see again that it's a petition for writ of habeas corpus. And the file size is 33.99 megabytes. And this is important, right? In case, the clerk changes the document or something, remember that number. It should weight that. And it should have 432 pages because of the attachments, the interesting attachments that I put into this thing, right? And the document basically describes the emergency. I invite you, if you're interested in this topic, to read it. But it has interesting attachments. Let me tell you what I put in here. So first, I put the silver-verified motion to recuse, which is the source of the entire controversy, right? Because I'm arguing that the court is under mandatory stay, and they keep creating hearings, not inviting me, then creating orders, not sending them to me, and then finding me in contempt, and then creating more orders, including the capias order to arrest, please. And it has a bunch of things. Just one second. Yes. Yeah, this is important. Yes. So after I realized, I'm talking about this thing, realtors emergency mandatory jurisdictional motion for the novel hearing. On this case, right, and this is on the index 215, right? I mean the motion, not the order. The order, the order that this is asking for a de novo hearing, and I'm going to give you details on what it is. It's an older hearing. Okay. But this is important. I want to give you the backstory on how this developed. This, I think, is the how do you call that? It's a silver bullet. Right? So when I realized, right, that they signed the capias and that this is a mistake because it basically disables their main weapon of attack, which is inaction. Because now I have the recourse to file this petition for habeas corpus. Right? I started thinking, how could I generalize this? I mean, could I abstract this in a way that allows me to use the same principle multiple times? Meaning, can I find ways that disable the inaction of the court? That was my thought. Well, then I thought, well, if I want to disable the inaction of the court, what I need to do is to find things that in which they are mandated to act, right? Quickly. So one that I know is the motion to recuse. That's what I've been using the motion to recuse before, because I know the judge is obligated to respond to that. He cannot ignore that, right? And in fact, he doesn't ignore it. He refuses to recuse himself, but he doesn't ignore it, right? Because he can't ignore it. The petition of habeas corpus, the same, right? I mean, these courts have to respond. I mean, they can't escape this, right? They can't let this hanging for 6 months. But I started thinking, okay, what else can I do, right? So I started looking up online, and I found that in the Texas Family Code, there is a provision in the section 201.015, I think it is. So 201.15, in which it gives the right of a party in a family dispute. This is specific to family law in Texas. Right? It gives the right for a party to ask for a de novo hearing. And I'm telling you this specifically because this type of hearing, and I'm going to tell you what it means, but it has a provision that makes the processing, the addressing of this motion by the court mandatory. Is a non-discretionary duty of the judge. When any judge in Texas receives a motion for a de novo hearing under Texas Family Code, section 201.015, they are obligated to respond swiftly. They can't delay it and they can't ignore it. So I say, well, perfect. Like, let me see if this is something that could be applicable, right? Now I have to take you back in time and show you again the docket and take you back to when all this began on April 2025, when my son was taken from the home, right? And again, trying to do this in the most clinical way possible. What I want to show you is two things, right? First, they initiated this case. So this is the very beginning of the case, as you can see here, right? They created the case, right? And then they said notice of hearing for temporary orders and order to appear, right? Index number 3. But as you can see in the following entries, there is no service. They never served me with that notice of hearing. So I could not go to the hearing, which, if you see, is the same thing that they did with the CAPIA's order, with the order to appear, and with all those the orders for contempt. It's the same thing. They create situations in which the target cannot attend to the hearing, because if they can't attend, they can't defend themselves. They don't even know what's happening, right? So they created this divorce case, and then they created this hearing, but they didn't serve me with the notice of hearing, right? So I don't know at this point in April 8th that there's going to be a hearing, right? Now, this hearing, as you can see on after the index 6, you can see in the entry of April 10, then there is a judge docket entry, meaning that they had the hearing, right? They had a hearing on, well, at least the judge reviewed the documents on the 10th. And then on the 11th, Judge Richard Bell, initial RB, says TRO sign, right? So they enter, he's saying that he signed a temporary restraining order. This is a serious type of order. These orders exist when somebody is a threat to a child or to a spouse, right? But he's signing this, and as you can see in the docket, I wasn't in the hearing because I was never served with a notice of hearing. I wasn't even served with the existence of the divorce case. Now, if you advance in time to April 16, I think, or here it shows April, yes, in the entry of, and this is kind of, you can see here how this docket was manipulated, right? So there is an entry on 4/11/2025, right? So April 11, right, 2025. And it says that I was served, right? But if you look at the date of service says April 16, 2020, 2025. So the question that you have to ask yourself is, how could the clerk have created these entries for the service on a day that was 5 days before I was actually served. I mean, this clerk has precognition, basically, right? Like they developed precognition. They knew on the 11th that I was going to serve on the 16th. I mean, this shows you that they manipulated this document. But that's not the important thing. What they served me with on the 16th was the divorce papers. So the start of the case, and they put in that a standard, what I think it's called a standard injunction, mutual injunctions order, right? So they included this standard temporary mutual injunctions divorce with children order in that package, and they included this notice of hearing for temporary orders and orders of hearing, right? That's what they included. But the title was changed deceptively to say temporary restraining order, right? And I posted this document before. But so they served me this Frankenstein package that didn't really contain the TRO. And they served me this on the 16th, right? I don't know, 5 days after, Richard Bell signed the actual TRO, okay? But they never gave me the TRO. I don't have a copy of the TRO, okay? Now, importantly, this is important, and I've talked about this before, you can see here that there's an index missing. So it goes from the request index 6 to the temporary restraining order index 8. So index 7 is missing. That is because they have a second version of the order, which is what they served me on the 16th, that Frankenstein document, right? So if anybody, so that this gives them the latitude to shift, to swap the documents, right? So if the DOJ or an investigator comes asking for the order, they will show them, the order, the actual TRO that Richard Bell probably signed, that I haven't never seen because they didn't give it to me, but that justifies the child being taken, right? Because supposedly I'm delusional, crazy, and all those things, right? But if I go asking for the order, if I go to the clerk's window, which I did before, and I have a copy that the clerk gave me, and it's not a real TRO, right? It's this Frankenstein document that is really a notice of hearing. That's what they gave, right? When I asked for index number, for that index number, for the temporary restraining order. So, importantly, during all this year, that index number 8 has not been downloadable. It was marked as a private document. So if I try to download it, and in fact, I did this live in a demo, I think it was like around August 2025, last year. This is recorded in one of my demos before, that I tried to click on the document and I could not download it. Right? So there's proof that this document was hidden. But yesterday, they made it downloadable. And the informant warned me that they made it downloadable. And I checked, and yes, it's downloadable. And now, when you click on download, you get the same version that they served me on 2025. So not the real TRO. And this is important, right? What this means, what this tells me, is that they're committing to the position that the index number 8 is not really a temporary restraining order. So they're going to say that this was a clerical mistake. That the clerk made a mistake and put TRO, but this is not really a TRO. There was never a TRO. So they're committing to that position, right? Which is interesting because it means they're rolling it back. Because if there's no TRO, then what justifies the child being taken for a year? My parental rights being stripped for over a year? What justifies the sanctions that Repiquet is seeking? What is the justification for all of this, right? So what they're doing is throwing Gloria Spin under the bus. That's what they're doing, right? They're saying that she took this action of taking the child and sequestering the child from me, secreting the child and all that on her own. That's what they're going to say, right? That she had no order to do this, right? Which I guess, I understand the logic of doing that, right? Anyhow, but I'm telling you all these. It's not an exercise on memory. I'm telling you all these because you see, in this sequence, I was first never served with even the notice of the hearing taking place. The hearing that would cause eventually a temporary restraining order that would allow my child to be taken and secreted from me for 50 days. 50 days in which I didn't know where the child was. I didn't even know if he was in the country. She wouldn't talk to me. She wouldn't, nothing, right? She and Morgan Hypner, right? Morgan Hypner assisted her in securing the child for 50 days. And I have emails to prove this. And Morgan Hypner works for the Adams law firm. And the Adams law firm is directed by William Kyle Adams, who is related, has a family relationship with the Chief Justice, Terry Adams, of the First Court of Appeals, that is not responding to the habeas corpus. You see, it's explosive, right? So, but I'm telling you all this, it's not an exercise in memory, it's to tell you about the de novo hearing, right? So the de novo hearing is this instrument in the family law of Texas that allows a party to ask for a new hearing. And it has a time clock. You can only do this within 3 days of the proposed order being filed. Right. So if there is a proposed order that affects the family relationship, you have 3 days to ask for a new hearing. And this is guaranteed by law, that you have the right to ask, not that you are going to have the hearing, but that you have the right to ask, and that the judge is going to process this motion quickly and without delay and in a mandatory way. Like they have no discretion to ignore this. Right? So the way this works for me is because I have the right to ask for a de novo hearing on this hearing of April 2025, even if the 3 days pass, because the 3 days, my argument is the 3 days never started, because I was never even notified that there was a hearing. I mean, if I was never notified, how could they start counting the 3 days? It doesn't make sense, right? So my argument is, listen, you never notified me of the hearing. You had the hearing anyways. You enter orders that affect the family relationship. And then you didn't serve me with the order. So, of course, I have a right to a new hearing, and I'm asking for that right. So now this puts the judge in a position in which, for the first time in a year, he's mandated to respond to a substantive motion of mine. That is not a motion to recuse. It's an actual motion about the kidnapping of the child, in which, and in this motion, it is very well detailed, this sequence of events that I'm telling you, on how they kidnapped the child with this dual version order hidden using Tyler technologies. So when the judge reads this, he has, I mean, you know, he has no choice but to report this to the DOJ, I imagine, right? To somebody, like to some higher authority about the corruption, because he's supposedly not aware, right? But if he becomes aware by reading the motion, he has to report it. He has no escape from that. And he has to return the child immediately, right? Um, but he chose so far, right? Over the last 10 days, he hasn't responded. So he has abdicated his mandatory responsibility of responding to this motion. So, it's checkmate. So it's checkmate if he responds, it's checkmate if he doesn't respond. Because it precisely proves my point, that this court ignores all my motions as a way to further the harm caused by the motions that are granted to the opposing party, without hesitation. So this motion for de novo hearing is on index 215. And you can see it here, right? I'm going to read to you the title. It says, Relator's Emergency Mandatory and Jurisdictional Motion for de novo hearing to compel production and to clarify status of automatic stay in light of imminent threat of unlawful arrest and confinement. This is because in the same motion, I injected in the prayer, in the second item, a direct question asking the court to clarify their position about whether they are under an automatic stay or not. When they read the motion, they have to address this prayer, right? And then they will have to take a position on whether they are under mandatory stay or not. If they say, no, we're not under mandatory stay, they would be admitting that they are defying the authority of the Supreme Court of Texas. Please. And if they say, yes, we are on the mandatory stay, they would be admitting that they have been harassing me with these void proceedings and void orders for at least 4 months. I mean, since January 14, 2026 until today, resulting at the end in this capias order and an order for my arrest, right? That, but even if the order is not posted and not served to me, but in any practical sense, it means that I cannot even leave my house. And I haven't left my house in over a week, even though I don't have food to eat. Right? So, I mean, so this is getting into a territory of violation of human rights, really. Like this is beyond, criminal. Like this is a crime against a human being, right? Like this is this is a violation of human rights at this point. It's not even a civil or criminal matter. Right? Because when you deprive a person that reported you to the DOJ of food, I think this is getting into a new territory. I mean, that will be my contention. Um, so I don't know. Uh, I'm gonna take a quick break. Yeah, because as you can see, these things. I'm trying to do it as objectively as I can, but obviously I'm a human being, right? And so I'm gonna take a quick break, and I'll continue in a few minutes. Okay. Thank you so much, and I'll see you on the next part.